Which is better to protect your assets for your family in the event of death or incapacity, a will or a trust? Let's find out.
I'm Neal Bartlett, and this is Jason Knight with Island View Law, and we help people protect and transfer their assets from one generation to another. One of the most difficult things your loved ones will face will be in administering your trust when you're gone. In this video, we're going to walk you through the difference between having a will versus having a trust. As we age and get into our golden years, it's important to have instructions of what should happen to your assets upon the event of death or incapacity. Have you ever asked yourself, is a will good enough or do you need a trust? I understand it might feel odd or even scary making a will or talking about your own death, but the alternative is that you are not the one in control of what happens to your estate.
After working a lifetime of building up your assets, isn't it better for you to decide who gets them when you are gone? A carefully crafted will ensures what happens to your assets after your death. It will accurately transfer your assets to your beneficiaries, which can avoid costly disputes and family conflict. However, having a simple will is no longer enough in this complicated time. Consider how you would feel if you left all of your assets to your spouse outright, as many people currently do using a simple will. If your spouse remarries after you die, all of your assets and possessions may go to their second spouse and not to your children at all. Or imagine if your spouse ends up in a nursing home or needs long-term care. Your estate may be eaten up by these costs, leaving nothing for your children or grandchildren.
So even the best drafted will should be reviewed every few years to make sure it still fits your needs and wishes. A big downside of a will is it must go through the probate process. In probate, the will would have to be publicly filed with the court, and the court supervises how your estate will be distributed. In California, this process generally is expensive, takes a year, and can take much longer if there are any issues with the will or any family disputes. Perhaps most important of all, wills only take effect after your death. The preferred way to protect your assets during your lifetime and after is to use a trust.
A trust, on the other hand, has many benefits. Specifically, you can avoid probate. But there are different kinds of trusts: irrevocable life insurance trusts, asset protection trusts, and special needs trusts. Each one of these trusts have their own benefits. That's why it's important to contact a qualified estate planning attorney to discuss each one of them. The right protection for you will be based on your situation. You need to determine which type of trust is most appropriate for you and your circumstances.
We want to help you plan what to do with all of your assets so that your wishes are clear and your family is protected. Schedule a 30-minute call with our firm and we'll analyze your entire situation, then provide a clear plan to ensure your wishes are carried out. You didn't spend your life working for something that cannot be shared or given to your loved ones, so don't. Plan your estate so you can protect your family today.